And we are recording. Okay, thank you everybody who's able to be with us this morning. We wanted to share an update with you about some changes we need to make in regard to our procedures around evaluation and eligibility determination. And the reason we are here is that these changes arise from an ALJ, Administrative Law Judge's decision, that occurred back in March of 2017, which immediately impacts our work. The parents of a child by the initials AW called into question the practices of Urbandale Community School District, Heartland AEA, and the Iowa DE. And basically what they're calling into question is the special education procedures as they stand in the state of Iowa. There were a number of issues that came into play. One was whether or not the eligibility criteria and procedures used by the school district AEA and DE illegally restricted the scope of entitlement to special education, and whether the school district AEA and DE violated procedural requirements by DEA by allowing eligibility determination to be made by the AEA rather than by the IEP team, and whether the school and AEA and DE violated child fine requirements by failing to identify the child in question, AW, as being entitled under IDEA. The administrative law judge found in favor of the parents on 4 counts. The first count impacts how we look at discrepancy. The second count looks at how we consider progress in general education. The third count has to do with parents being reimbursed for tutoring, and then the fourth was about parents being reimbursed for attorney fees. And if you've been around special education long enough, you know that's not unusual. Whenever a parent prevails, that they get awarded attorney fees. We'll explain more about the first 2 findings since they're ones that obviously directly impact our work. We're going to discuss changes in practices that we need to make immediately, and we'll share initial thinking and what we can do differently. And just so you know, this is a work in progress. This is not written in stone today. This is how we're going to do things. It's our best thinking at this time, and we will continue to work on it and think about it as we move forward. Ron?
Yes, I just want to take a few minutes to kind of talk a little bit more about what happened in the AW case and the issues that were raised, just to kind of give you some context about the decisions that were made. This was a situation of a student who had been referred for special education by parents, and there were lots of evaluations involved. Parents had, so there were a number of complicating factors. Parents had outside evaluation information. In the midst of the whole case, there were several evaluations done in school, and the decision of the school team was that the student was not eligible for special education. However, outside evaluations suggested learning disabilities. So, for example, there was a University of Iowa evaluation that indicated nonverbal learning disability. There was another outside evaluation actually done by a speech-language pathologist that documented a form of dyslexia. So the word dyslexia came into the case as well. But what you're seeing on the screen here are actually a number of things that were issues that were raised. So one issue was that there was an accusation that there was an omission of considering a pattern of strengths and weaknesses in performance or achievement relative to intellectual development from the disability determination for the student suspected. So that gets into that illegal restriction part again. So the suggestion was that rather than relying specifically on a discrepancy in the area of achievement, there should have been a more in-depth look at a pattern of strengths and weaknesses. So for example, AW, some of his information, some of the information is indicated in the case, and you would see percentile scores that traditionally we would not say are significantly discrepant. So that the next point on the screen that you're seeing there, failing to give good faith consideration of clinical diagnoses of LD by qualified medical professionals. So there was this distinction between medical disability versus an educational disability that issue has been floating out there before. And so it was not saying that the district or AA must follow the exact recommendations of medical evaluations, but the call there was, or the question was, are you failing to give good consideration to that type of information? Then the third one on the screen there, failing to make an individual determination of need by requiring a significant discrepancy from norm or age or grade-based standards. And so then overall, the question called into play was, are you narrowing the definition of special education in a way that, and I'll just read that last point there, narrowing the definition of special education and specially designed instruction so that it includes only instruction and services that exceed the capacity of general education. So that was also called into play, this issue that there was a position from the LEA and AAA saying that AW is doing okay with these general ed interventions, but the question was, does that mean that the AW does not have a disability? Could his needs be met within the scope of general education? David, would you shift to that next screen for us? Thank you. And so then at the top of the screen you're seeing right now, the last two issues raised that was mentioned earlier. Did the respondents violate IDEA by making eligibility determination to be made by the AA rather than a team? So that was a question there too. Even though that has been the model in Iowa for many years, that the AA has a large role in child find and a responsibility for child find. The question was the decision made more heavily by AA rather than an eligibility team? And then the final question was there a violation by failing to identify him? Was this a student who does have a disability, and there was a failure to identify that student? So you can see that little paragraph halfway down the slide there. If you were to read the whole decision, there's about a 70-page decision you could read, and I believe some of the materials that have gone out to people, there's a link where you could read that. But lots of issues in this case. One that I didn't mention earlier, this student was also a homeschooled student for many years, then came back to school. So there was the issue of instruction that came up in the evaluation. Were the struggles possibly somehow due to lack of instruction because of the homeschool situation? This student also received tutoring outside of school, mixed into the whole situation with the many evaluations. There were medical versus educational conceptions of reading disability or of dyslexia. The use of discrepancy for peers, and this issue of not using more of a profile versus just looking at discrepancy. So, David, if you click on that order of relief, that's kind of that will take us to this large document I mentioned where it is a fascinating case, and some of you may want to read the 70 pages, but we're going to jump to the end here that just points out the order of relief, and you can see those 4 points there that were alluded to earlier, and that's going to translate into some of the things that we believe we have to do as an AEA. And number one, the Iowa Department of Ed shall not require the AEA and district shall not employ criteria that make a finding of disability under IDEA contingent upon existence of a significance of severe discrepancy. So very directly said, we shall not do that. Number two, the Department of Education shall not require the AA and district shall not employ, and I'll read this verbatim so that it's hopefully a little bit clearer. This is one that I had to read several times to have it sink in for me. Shall not employ a definition of special education for purposes of determining whether a child needs special education as a result of a disability that excludes instruction adapted in content, methodology, or delivery to meet the needs of the child merely because the instruction is within the capacity of general education. So that raises that issue of could needs be met within the capacity of general education and the child still has evidence of a disability. And when you get into 3 and 4, that gets into award of attorney fees and reimbursement of tutoring. I'll stop there. And so numbers 1 and 2 leads us into our next point of discussion here.
Okay, thank you, Ron. So as Ron mentioned, there are some main issues, and then some kind of side issues, but important ones. First of all, don't ignore outside evaluations. Get that information right away from a family and consider it at the team meeting. Make sure parents understand the evaluation process and how decisions are made. And then also that piece about not even appearing to be having decisions made by one person, whether it be the AEA or LEA. So just because one person might be writing a report does not mean they're making the eligibility determination. That is a team decision, and make sure that we don't have the appearance of one person making a decision, that we allow that to be a team decision. What came more recently was a memo from the Iowa Department of Education, David Tilley, on September 26th. And this was in regard to the decision made by that ALJ. And basically what it boils down to is once that decision was made, that then became the way we needed to practice. Each AEA, however, except for Heartland, where this happened, waited to get direction from the DE, and this is that direction that we were waiting for. And so they talk about the ruling and what it means. And what it comes down to, if we look at this last paragraph, the current version of the EA Special Ed Procedures Manual, however, provides several examples of the use of significant discrepancy, which were in conflict with the AW decision. So you can see the underlining part there. Staff shall no longer use the following as a determinant factor in eligibility decision. Cutoffs are approaching a cutoff for discrepancy times discrepant. So basically, just laying out a number and having that number be the determinant factor for indicating whether or not a child has a disability. So whether, if that's a 13th percentile, whatever it might be, we need to move away from that and get into different ways of looking at a child's need. The other piece has to do with that consideration of general education's capacity. Well, first of all, this memo talks about consideration of general education and whether or not they received appropriate instruction in the first place, and that is an important consideration. But again, like with we shall not use the discrepancy, now we shall not look at capacity of general education to determine whether or not a child is a child with a disability. Because what they are arguing is that, and what has come down is that a child could be receiving accommodations, modifications, interventions in the gen ed setting and still be considered a special education student. And we'll get into that a little bit more here too. So that's the memo from the DE. And so basically this slide just kind of reiterates that. No longer using the discrepancy cutoffs. And so one of the directives we've given our staff in the past couple of weeks is in that last column, that discrepancy column in the EER. We are saying no longer fill out that column with a number. Basically, we're telling them to say see below, and then there'll be more narrative. And we'll give you an example of that in just a minute here. And so staff will no longer use those numbers, the times discrepancy ratios, et cetera, as mentioned in the memo from David Tilley. And we will no longer use a single score to indicate if a child has if they're significantly discrepant or not. And that's been good practice for some time now, that you don't use one score as the factor for determining whether or not a child has a disability. You really need to look at the preponderance of the data in making that kind of determination. So again, just some language that we need to drop out of our use. And so use of the phrase significant discrepancy or severe discrepancy will not be used. And again, what's more important is to look at the EER to show what we learned from the diagnostic assessment that we just did. So we've just, put the child through a lot of assessment. We evaluated them in a number of different areas. And so what is it we now understand about this child's strengths, weaknesses, and what those things mean functionally for that child within the classroom setting? That's really where we need to direct our practice. So we need to operationalize their academic performance given all that we've learned and not focus on a single cut score. And so we're really going to have to get better about developing our qualitative description of the student's performance in the classroom. We can still use numbers, but those numbers cannot be a sole factor for, a determining factor for identifying them. It's just got to be a piece of the bigger puzzle that we have. So we have for you an example here from Sammy Sloan.
Thanks, David. If you'll scroll down to page 6, as David and Ron described, we will no longer be using filling out the last column on the table in the EER where it asks for a times discrepant. And I'll wait just a minute. So as you can see on this table, an example of an EER, we still fill out the column that says area of concern. Then we fill out the data source, dates. We can still fill out the peer expected performance and then the individual's current performance. We will no longer be filling out the discrepancy from expected performance. We will be noting see below. What we will be doing to summarize in narrative form, the 2 questions below the table will now be a narrative of a pattern of strengths and weaknesses for the child. So we will be talking about what strengths and weaknesses the child has in all the assessments that we have done and completed. And we'll just continue to do that until there's more guidance. But it will be a summary of within this assessment, this is what the student has as strengths, and here are some weaknesses. And we'll talk through that with those questions. Thank you, David.
Thank you, Carissa. So the second finding's implication is we can no longer discuss the capacity of general education in considering its students' needs. That's been a long-standing way of looking at it in Iowa. And so we're no longer to employ a definition of special education that precludes a child from being identified just because they can get their services in general education. So this one's probably going to be one that we're going to struggle with. Actually, we're going to struggle with both of these for some time, and that's okay. We want to make sure that we get to the right and the best practice for all kids. And so again, what we're offering you today is our best thinking at this time, and we'll continue to update you as we get to a place where we think we are in a better place to identify these things and have conversations around these things. And this is a state issue, so we're doing this along with other AEAs. So instead of looking at gen ed capacity under need, we're going to focus on some other things.
Yes, thank you, David. So under that needs focus conversation, that last portion of the EER that most of the SPED reps will be filling out, instead of focusing on that gen ed capacity, we're going to be focusing on determining those skills that the child needs to be taught in order to access the gen ed curriculum, and work on summarizing what was learned from the data and what type of research supported the strategies that were implemented throughout the evaluation. And then we'll really summarize those specific interventions that worked or didn't, and describe that instructional modification that needs to take place. So instead of focusing on this is what they need in gen ed to be successful, this is where we kind of summarize that patterns of strengths and weaknesses. And where this really leads up to, if you want to flip to that next slide for us. That final question on the EER that we're asked to address in that needs portion is which of the above needs, if any, require services and supports that exceed the capacity and obligation of the gen ed program and resources. So to address that question from here on out, what you'll find in those EERs is a statement just saying that at this time the eligibility team will meet to review so-and-so's assessment data and identify the educational needs to make that decision. So instead of saying that it is beyond the obligation of gen ed, falling back to that team default.
Thank you, Stephanie. So, in conclusion, this case is currently under appeal by the Department of Education, and you know, that could take some time. It took this case several years to work its way through the system to get to a decision in March of this year. Given the appeal status, there's very little conversation with the Department of Education about the implications and remedies. The special education directors had a meeting last week to discuss this case and where we were going as a state. And there was a representative from DE who sat there just to listen in. They really couldn't offer any thinking or input about where we were headed. There are some things about our practice that we must change immediately. And again, as I've indicated before, the we here is the entire AEA system, not just GHAEA. And we're going to take the rest this year to really work on our evaluation practices and focus on what we can do to improve them. You know, you can always look at a situation as being, you know, something bad or as an opportunity to, you know, change some things that you would have liked to change anyway. And I think that's the way we need to look at this one. I'm going to look at this as an opportunity to refine our practices so that we can better address the needs of students requiring special education. And so also there is a document that's been put together that will show you some things that talks more about what we've talked about today, and that link should take you there. And we'll share all this information via an email as well. But this spells out what we've been talking about here this morning already and gives you some of the background information, some things that we need to do as we move forward. I also wanted to give you a heads up that about a week ago, Decoding Dyslexia Iowa started advocating as a result of this case. And this was a posting on their Facebook page on October 6th. And they were saying if you believe your child was found to not have a disability due to that discrepancy issue or because of general education's capacity, then you should ask for a new evaluation if you felt your child was found not to be eligible because of one of those two things or both. And then they also offered, if you'd like to speak to an advocate or attorney, please contact us and we'll send you a list of resources. What I would ask is that you let your special ed reps know if you have parents calling about these things. I'd like to kind of keep a finger on the pulse of this to see. I'm not sure how many we will see and get kind of how many requests we'll get around this topic. We could get some, you know, and we just need to take each case as it comes. And if a parent does request it, and you know, if one of these things were a reason why a child was found to not have not be in need of an IEP, then we do need to have, you know, come back to the table and have a conversation and work our way through it case by case. I want to thank all these people for their help in really working through the information in this case. It really is, there's a lot of pieces to it. I want to thank Carissa, Ron, Stephanie, Angie, and Joe for their input on all of this as we move forward as well. We do have an FAQ spreadsheet that we'll be sending out as well. We would like you to put any questions you have in that spreadsheet. What we will do is respond to the questions either as they come in if we can, or if it's a question that we need to spend some time thinking about, we'll try to get back to it, you know, within a week's time once it's posted. And just make sure you keep that link on your desktop or something so that you can refer back to the FAQ. You know, we have a couple of minutes left. I just wonder, are there, we can maybe field a question or two right away if anybody would like to do that. one of the questions was, will we share the PowerPoint? Yes, everybody on this morning, everybody, all SPED coordinators, let's send it out to the listserv. We'll get everything that we've talked about today, including the PowerPoint. Ron, Stephanie, Carissa, anything from your perspectives?
Nope, I think that covered it.
I agree.
Okay.
Just one thought that I had, and it was in the PowerPoint, but just a reminder, we've had some conversations with staff where there were some misperceptions that this means there will never be a score or a number or a percentile listed in a report again. I mean, that's not the case. It's just really that issue of using a percentile or a score in a way that's saying, Susie does or does not qualify because of being discrepant enough. But there'll still be opportunities to use standardized scores to talk about the impact on that child. So it does not mean scores will never be there. It's how we use the scores for eligibility decisions.
Okay, thank you, Ron. All right, thank you to everybody who joined us this morning. Again, this was recorded, so we will get this posted later. Oh, Angie is asking about anything about reevaluations. Same considerations for reevaluations as for initial identification. We have to look, we no longer use that discrepancy piece the way we've been using it. Again, it's looking at the preponderance of the data. All right, thank you, everybody. Have a good day.